California has always been slow at building more desalination plants. Jeremy Talcott, attorney with Pacific Legal Foundation, tells California insiders Siamak Karami that the California Coastal Commission has a lot of power in approving projects. He gave an example of two different projects with very different outcomes.
The much larger project, a $1.4 billion desalination plant that would have produced 50 million gallons of fresh water per day, was not approved. And that's despite, again, 20 years of environmental assessment, approvals throughout every other level of government, and even the support of Governor Newsom. And nonetheless, the commission was able to completely stop that project.
Talcott says the commission did approve a smaller project in October that would cost less but also produce much less water per day.
What that shows is that, again, the commission wields a tremendous amount of power over the California coast and whether projects may or may not go forward. And oftentimes the justifications or criteria that the commission might use to make those decisions can be somewhat opaque.
Talcott explains that the commission's 12 voting members are appointed, not elected. Established in 1976, they are environmentally focused and their job is to protect the coastline. But even if a project appears to be approved, there are still caveats.
And those conditions include that the developers of the project resubmit additional plans to the executive director of the commission, which the commission is still free to reject. So even though they technically have an approval at this point, it's still not yet clear that they will be able to move forward and actually begin development.
Talcott's nonprofit organization pushes back on the commission because their power has expanded to interfere with individual property rights.
So if you want to build along the coastline in a region that has a certified local coastal program, you will go to the local government first. You will submit your plans to them, they'll review, they'll determine whether or not your project is consistent with that local coastal program, and then if so, they'll approve it. But for areas within, especially very close to the coast, the commission retains appellate authority. And that means either a local activist group, a concerned individual within the area, or the commissioners themselves can step in and take an appeal of your permit approval and then reverse the decision-making of the local government.
For years, the commission could only fine people through the Superior Court after presenting thorough evidence. But recently, they have gained the ability to fine directly with almost no due process.
In 2014, what was added is the ability to fine for any violation of public access. So essentially, if the commission determines that someone interfered with the ability of the public to access the coast, then they could fine them up to $11,250 per day. So that's a tremendous potential penalty power. As of 2022, that power has now been expanded, and they have the ability to fine $11,250 per day for any violation of the Coastal Act. And it's important to note that now that they no longer have to go before an independent judge, this is a power that they can essentially unilaterally impose.
According to Talcott, the commission was designed to balance the power of local and state governments regarding coastal preservation. But now they are changing rules as they go, which is not what it was originally designed to do.